and welcome to the training for attorney volunteers on naturalization basics for citizenship workshops by the Office of Immigrant and Refugee Affairs for the City of Seattle. Thank you for watching this training. First, a little bit about what the training will cover today. We'll go over the legal requirements for citizenship, talk about the good moral character requirement and any red flags that we look out for, go over the N-400 form, go over the I-912 form, and then finish up. If you want more information about either the N-400 or the I-912, the N-400 is the citizenship application and the I-912 is the fee waiver form, please watch the trainings for the form station, which should be available to you. First, we'll talk about the legal requirements for citizenship. To start off, we want to make sure that your client is not already a citizen. The Child Citizenship Act, effective 2/27/2001, made it easier for children, legal permanent residents, or children when one of their parents naturalizes to automatically become citizens. Children under the age of 18 are not allowed to apply for citizenship on their own, but most LPR children can automatically gain citizenship from a parent naturalizing, as long as that parent is their physical and legal custodian. The child is a legal permanent resident when the parent naturalizes. It's important to ask potential applicants whether they have a U.S. citizen parent or grandparent. The new N-400 actually has a section on this. If they didn't derive citizenship under current law, you should consult the derivative citizenship charge for prior laws. This information is available in the attorney legal binder that you should have at your station. We'll discuss more about acquired at birth versus derived citizenship at a later point. Now let's talk about the basic eligibility requirements for citizenship. We'll go into each of these in much more detail. But you must be at least 18 years old. You must meet the residency requirements. You must meet the physical presence requirements. You must be a person of good moral character. You must be able to speak, read, and write some English. You must be able to pass a U.S. history and civics exam. And you must be willing to take the oath of allegiance. First, we'll talk about residence requirements. In order to apply for naturalization, the person must be lawfully admitted as a permanent resident for at least 5 years or 3 years if at the time of filing they've been married to a U.S. citizen for a full 3 years and they are continuing to live in a marital union. There are some exceptions to this 5-year period. There's a rollback rule for asylees and refugees, meaning asylees are considered to be legal permanent residents from 1 year before the LPR decision, and refugees are considered legal permanent residents from the date of admission to the United States as a refugee. Now, it's important that the residence be continuous. They have not broken their residence or abandoned their residence. Absences of less than 6 months are generally fine, trips outside the country, etc. Absences of between 6 months and a year may be a break in residence depending on the circumstances. If the client can prove that their extended trip was not planned or that they maintained a significant tie to the United States, such as maintaining a residence and a job in the U.S. during that time, they may be able to prove that it was not a break in residence. A classic example: someone who travels home and then must stay because of a sick relative or other circumstance outside their control. Any absence over a year is an automatic break in continuous residence. We are also concerned in this case about whether USCIS will find this person has abandoned their LPR status. If USCIS determines that it appears that the person intended to abandon their residence in the U.S., they may lose their LPR status and be put in removal proceedings. So it's important to explore all the circumstances around any extended trips. If there is a break in continuity, 2 years plus 1 day are necessary to reestablish. For a 3-year period, 4 years plus 1 day are necessary for a 5-year period. Also, for residence requirements, it's important that they have been a resident of the CIS district or state where they filed their N400 application for at least 3 months. If someone has moved to the state of Washington within the last 3 months, they should wait to file their application. They must also reside in the U.S. from the filing of their application until the oath. If the person has any travel planned between the application filing and their oath, you should be sure to check that with them and make sure that it's not going to be a problem. They may file as many as 90 days before the residence period, the 5 or 3-year period, is complete, but not more than 90 days. So if someone is almost at the 90-day mark, they can file. This is not true for the part of the 3-year rule that it requires being married to a U.S. citizen for at least 3 years. It must be a full 3 years, not 2 years and 3 months. There are also physical presence requirements. This means that the person applying for citizenship must be physically present in the U.S. for at least half of the statutory period, that 3 or 5-year period. If applying under the 5-year rule, that means they must have been physically present within the borders of the United States for at least 912 days within the statutory period of 5 years. Under the 3-year rule, that's 547 days. It's very important that if the client is anywhere even close to this number, we flag it for further consideration. Many people forget trips. If they've forgotten even one trip and they're close to that line, it could be in danger of not meeting this requirement. And again, we want to make sure that no single gap was more than 6 months at a time. Now let's talk about the English requirement. You must be able to hold a conversation in English at about the 4th grade level, according to USCIS. Citizenship requires basic English, not perfect English. This is a little bit of a fuzzy line because many of the concepts discussed at a citizenship interview are beyond the 4th grade level. But the important point is that they do not need perfect English. If someone can hold a basic conversation about their application with you in English, they are probably ready to pass the English requirement. If someone does not qualify for an English exemption, which we'll discuss in a moment, and they cannot talk to you in basic English, they are probably not ready to apply. This is especially true if they are completely illiterate in English. They must be able to read and write 1 to 2 basic sentences in English. We encourage anyone who's not ready to pass the English requirement to take ESL classes and study more, but ultimately we leave the decision up to each person if they want to move forward and if they feel that they can improve their English sufficiently within the 3 to 6 month period between filing their application and having to take their interview. Now let's talk about exceptions to the English requirement. If the person is over 50 and has been a legal permanent resident for at least 20 years, or over 55 and has been a legal permanent resident for over 15 years, they do not have to pass the English requirement. They can take their interview and their history and civics exam in the language of their choosing. It's important to note that they must meet both the age and the residency amount of time. There's no exception for age alone. So even if someone is 120 years old, they've only been a legal permanent resident for 5 years, they must pass the English requirement or wait at least another 10 years. If they qualify for an English exemption, they may bring an interpreter to their interview and take the test in the language of their choice, but they do still need to take the U.S. History and Civics exam. People who have a medical condition or disability that prevents them from learning, such as a stroke, dementia, or Alzheimer's, do not have to pass either the English or the History and Civics exam. However, this requires a doctor's note and is a strict medical, not legal standard. We'll talk more about this in a moment. But first, let's talk about the U.S. History and Civics exam. Applicants who qualify for an English exemption still have to pass this exam, but they can take it in their own language. There are 100 possible questions to study from that cover U.S. history, geography, government, and culture. Applicants will be given 10 questions the day of their interview and must get at least 6 right. If they get the first 6 right, the USCIS officer will actually stop giving them more questions. Applicants who are over the age of 65 and have been legal permanent residents for at least 20 years can take a shorter version, of which there are only 20 possible questions to study. They'll still need to answer 10 during their interview, but the pool of questions that they have to study is much smaller. Now we're going to talk a little bit about the medical and disability waiver, otherwise known as an M648. This creates exemptions for applicants from the U.S. History and Civics and English requirements. There must be a medically determinable physical, developmental, or mental disability that is expected to last at least 12 months. The standard is that the applicant must show they are unable to learn due to the disability. An MD, DO, or psychologist must complete an N648. It cannot be completed at a citizenship workshop, and it cannot be completed by anyone other than a medical provider, as this is a medical determination, not a legal one. It's very important that we refer people who may qualify for an N648 out, because these are some of the most vulnerable clients, and we want to make sure they are completely taken care of and they have someone to follow them throughout the process, not just for this one intervention. Now we'll talk about good moral character and red flags. Danger, proceed with caution. It's very important that we take screening and review of applications seriously at citizenship workshops. Citizenship workshops are designed for eligible legal permanent residents with uncomplicated cases who can go through the rest of the process without help or support. Any serious problem on a naturalization application would not just mean disappointment and the loss of $680. In some cases, it can result in a person losing their legal permanent residency or even ending up in removal proceedings and being deported. We are offering legal help with a serious process. We need all of our volunteers to be careful, meticulous, and committed. We would much rather err on the side of caution and advise someone to seek more representation than allow someone to go forward when it may mean risking their legal status or even their presence in the country. The good moral character requirement is the most complex requirement. It's intimately tied in with many other parts of immigration law and criminal law. Applicants must prove that they have good moral character in order to naturalize. Now, the standard is for good moral character, not perfect moral character. There are bars to proving good moral character that USCIS has laid out. We'll go over these in a moment. But it's important to note that some of the bars to proving good moral character also present removal issues or issues that can trigger removal proceedings or deportation. We want to pay careful attention to any good moral character violation that may also result in removability. We approach screening for the good moral character requirement in 3 basic steps. The first is looking at if the person is barred from establishing good moral character. In other words, do they have any mandatory bars against establishing good moral character, either permanent bars or bars within the statutory period. The second question is, could this person otherwise be denied based on the lack of good moral character? In other words, do they have any discretionary bars? Discretionary bars are bars that USCIS officers can apply, but they're not required to apply. They're not an automatic bar to establishing good moral character. If the applicant has demonstrated good character during the statutory period, USCIS cannot deny the application based solely on acts outside of the statutory period, unless, of course, these acts constitute a permanent mandatory bar. USCIS is also required to evaluate claims of good moral character on a case-by-case basis, including taking into account the standards of the average citizen in a community of residence. This is important because it gives our applicants some level of cover. They don't need to be perfect citizens. They don't need to be perfect people. They only need to show that they have good moral character as compared to the average citizen in a community of residence. The last question is, we need to make sure this person is not otherwise removable. If someone can or cannot establish good moral character, but they also have a bad act that can trigger removability, it's very important that we identify that and encourage this person not to apply, or certainly not to apply without legal representation. Generally, someone must show good moral character for the statutory period itself, 5 years prior to filing for the N-400, through to the oath ceremony, or 3 years if married to a U.S. citizen. Now, note, USCIS can look outside of the statutory period. The intensity of their focus will be on that statutory period, the 5 or 3 year period. Exceptions to this include any of the permanent bars, murder and aggravated felony. There are bars to showing good moral character. We can break them down into 3 main categories. Mandatory bars, which means that the person is automatically unable to demonstrate good moral character if they have any of the acts determined to be a mandatory bar. These include permanent bars that are for their entirety of their life, and temporary bars that are only an automatic bar during the statutory period. There are also discretionary bars. These are only bars during the statutory period, and they're up to the discretion of the USCIS officer. They won't automatically disqualify someone from applying for citizenship, but they are potential blocks to showing good moral character. Now, I'm going to talk a little bit about the good moral character bars in a little bit more detail. There are mandatory and discretionary bars, as we've discussed. Mandatory bars automatically stop someone from proving that they are a person of good moral character in the eyes of USCIS. Discretionary bars don't automatically stop someone from demonstrating good moral character. It's up to the USCIS officer to choose. However, that does not mean that discretionary bars are less serious than mandatory bars. A number of the discretionary bars can also put someone in danger of being removable. Mandatory bars, there are 2 mandatory bars that are permanent mandatory bars. Any murder conviction at any time, or an aggravated felony conviction after 11/29/1990 are permanent bars to demonstrating good moral character. Others are within the 3 or 5 year statutory period. If any of these acts occurs within that period, then the person is automatically barred from demonstrating good moral character within that statutory period. You can wait until the act is outside of the statutory period, and then it is possible to demonstrate good moral character, but we must evaluate carefully if that person is removable or if they face any other danger. So mandatory bars within the 3 to 5 year statutory period include conviction or admission of a crime involving moral turpitude in the last 5 years, 2 or more offenses with total sentences of 5 or more years, controlled substance violations of any kind, convictions with 180 days in jail, false testimony to gain an immigration benefit. alien smuggling, or in other words, helping someone enter the United States illegally, and this can range anywhere from physically smuggling someone across the border to sending money to a relative to pay a coyote in order to cross the border. Polygamy, prostitution, gambling, and habitual drunkenness. Discretionary bars include giving incorrect or false information, failure to pay child support, registering to vote or claiming to be a U.S. citizen, tax violations such as not paying taxes when owed, failure to register for the Selective Service, and any other criminal violation or unlawful acts. This is sort of the catch-all category that USCIS can use. And now, again, it's important to think of the discretionary bars as, well, there's some leeway whether or not USCIS must decide that this good moral character bar is keep someone from demonstrating good moral character for the purpose of naturalization, but registering to vote or claiming to be a U.S. citizen, for example, can lead to removability. So these are not less serious bars, they're just less of a clear outcome. It's really important that we look at mandatory and discretionary bars, and we think about that question of removability, because even if someone may be able to demonstrate good moral character, if there's any gray area or any confusion, we really want to err on the side of caution and err on the side of making sure that that person has legal representation as they go through the process. They may want to bring someone with them, an immigration attorney, with them to their interview, and really be prepared to mount a vigorous defense if that's necessary. Many of the things we've been talking about, if anyone is even borderline on good moral character, they're not the right fit for a citizenship workshop. Now I want to talk about our red flags checklist. The red flags checklist is the document we use at the screening station to check for red flags, potential problems with the citizenship application, and ensure the person is a good fit for a citizenship workshop. What you'll do is go through each of the questions with each client. They're structured so that a yes answer is the red flag. At the end, once you've gone through all of the questions, you'll assess how many yeses, get a little bit more detail on each of those, and then consult with your team lead to decide whether this person needs to be referred out for one-on-one attention, if they need more documentation or more information, and then referred out to a referral specialist who can help them to get that information, or if they are okay to go on to forms, or if they need to go to complex cases for further screening. We're going to go through the red flags checklist, the questions that are asked on it, and talk a little bit about some of the issues that we see with each one of these questions. Again, if you're in any doubt, you'll always want to check with your team lead. In fact, every client should check in with your team lead unless they have no red flags. But it's important to have a little bit of background so you know what we're looking for. First, the first question deals with acquired or derived citizenship. We're asking if either of their parents are a U.S. citizen and if they were under 18 when they naturalized, or if they were born U.S. citizens, their parents. If the answer is yes, they may already be a citizen. So we'll want to check the conditions of the Child Citizenship Act, if this happened after 2001, or the derivative and acquired citizenship charts, if this happened before 2001. This is actually fairly common. It happens at least once per clinic that we find out someone is actually already a citizen. This is usually great news for them, but we do want to make sure that they know what to do next and that they need to file an N-600 instead of an N-400 application. The next question asks about long trips, because trips over 6 months in length can mean that the client has abandoned their residency, and it can create a break in their residency, so they may not be eligible to apply for naturalization at this time. And more seriously, if USCIS finds that they have abandoned their residency, they're at risk for losing their status as a legal permanent resident. Trips over 6 months can be a break in residency unless the client can prove otherwise, by proving that their trip was extended outside of their control and they maintain significant ties to the United States. Trips over a year are an automatic break in residency. Lengthy travel can cause problems, as I said, in naturalizing or even the loss of LPR status, and it does require, even if it's not going to be a problem, It does require a more significant amount of paperwork to be attached to the naturalization application than we generally can help someone put together in a citizenship workshop. So it's very important to establish the length of the trip. If they said they have had a long trip in any time since becoming a legal permanent resident, the reason for the trip, the types of ties the client maintained here in the United States. Example, did they keep their home here? Was their family still here? Did they keep their job in the United States? Just to get a little bit more detail. And then you'll check in with your team lead to decide if this is something that needs to be sent to complex cases or someone who should be referred out to go get more information and get some one-on-one help. The most important thing is making sure if the trip is under 6 months, then it's probably fine. If you have a trip that's 5 months and 25 days, maybe we also want to look at it. But as long as it's generally under 6 months, they're fine to go into forms. Anything over 6 months is a concern that we want to probe a little bit more into. Questions 3 through 5 are regarding English and civics requirements. These questions appear to screen applicants who may have problems meeting the English and civics requirements. The first is trying to find out if people may qualify for a disability waiver. As we've discussed, disability waivers cannot be completed at citizenship days. They require a medical determination, not a legal determination. They require a doctor to fill out the form, and these clients generally require one-on-one assistance throughout the process. Then we're checking to see if the person qualifies for an English waiver. If yes, then you don't need to look more into their ability to speak and read English because they will be able to have that waiver. However, if the client does not qualify for a waiver, you want to look at, are they able to converse with you in English? Are you able to have a basic conversation? And are they literate? Do they have a basic level of literacy in English? There's a card provided at your table that has a simple sentence that you can read to them and have them write down, and a simple sentence that they can read to you. So, in other words, can they write and can they read? If you find that the person is totally illiterate, or if their English level is really not at the place we need it to be in order for them to pass the citizenship exam, English exam during the citizenship process, we strongly encourage people to go to ESL classes and begin to prepare. The 3 to 6 months between filing the application and the interview goes quickly, and it's difficult to make a huge amount of progress in that time. We really encourage people to wait if they're not ready. However, all of our clients are adults. It's their decision, and if they feel that they want to try to study and get their English level up, that's their decision. Questions 6 and 7 look at failure to pay taxes. We ask about taxes because the failure to pay or file your taxes is a discretionary bar to showing good moral character. However, if the client is too poor to have owed income taxes, this is not a red flag. That's not a problem at all. If they did not meet the level of income necessary to have to file taxes, then they have not failed to file taxes. They simply did not need to. If they have gotten behind on their taxes or failed to file taxes and have already established an active payment plan with the IRS, the client can go forward to the form station, even if the balance is not paid off, as long as they're sort of in agreement and making progress toward paying that off. It should be fine. If they have taxes that are owed, they have not begun to pay off, they have not contacted the IRS to set up a payment plan, then this is a red flag, and you'll need to consult with your team lead about what to do, but likely this person will need to be referred out. Selective service registration is one of the most common red flags that we see in men. All males aged 18 to 25, except non-immigrants, so if you're here on a tourist visa, for example, are required to register for the selective service regardless of status. That means even undocumented people are expected to register for the selective service. If the client is unsure if they registered during this 18 to 25 window, you can check their registration at www.sss.gov. If the client is still under 25, you should register them right then and there. If the client is over 26 and failed to register, this is a discretionary bar to good moral character. But once the failure to register is outside the statutory period, in other words, if it's more than 5 or more than 3 years ago, it can be used to deny their application. If the failure to register is not outside the statutory period, they can still show good moral character, especially if they can show to the USCIS that it was not a willful failure. We have an addendum prepared that states that the client would have registered if they had known that they were required to do so. And you can leave notes in the forms section for the forms station to fill out that addendum. It's also important to get a status information letter if they are age 26 to 30. Leave a note in the forms for that station. If they're older than that, it's just the simple question of showing that the failure to register was not a willful failure. Again, this is an incredibly common red flag, but it's not something that necessarily stops someone from moving forward outside of the context of other red flags. Now we'll look at voting or false claim to citizenship. This is a very serious problem. It can make someone removable. It's not an automatic bar to showing good moral character, but it is still a very serious problem. Someone whose parents are or were U.S. citizens or LPRs before the age of 16 who reasonably believe that they were a citizen at the time of the false representation can still show good moral character. If there's a conviction related to this, it may or may not be a crime involving moral turpitude, depending on how it was charged and whether or not it was a felony. However, this is a removal issue, even without a conviction. Any false claim to citizenship made after 9/30/1996, made to obtain any state or federal benefit, is a removal issue. Voting in violation of the law is also a removal issue. You have to look at the mens rea requirements of the law. And again, all of these carry the exception of if you reasonably believe that you were a citizen at the time. And there's some case law in McDonald v. Gonzalez if you want to look up a little bit more about mens rea in this particular context. There's also a memo that is useful if you want to find more information. The memo is from 2002, Procedures for Handling Naturalization Applications of Aliens Who Voted Unlawfully or Falsely Represented Themselves as U.S. Citizens by Voting or Registering to Vote. It's an ALA memo. And then notes, the specific information is in the notes of this slide if you want to get more information. The key things to understand here is the circumstances in which they voted or made a false claim to citizenship, when exactly this happened, and what the consequences were, and were this discovered, and how was it discovered. Very likely, if anyone has voted or has a false claim to citizenship, they will need to be referred out for one-on-one assistance, because this is such a serious issue that really can create removal circumstances where they may be in removal proceedings, and they will need robust defense. So we also ask about past citizenship applications. The important thing in past citizenship applications is to understand why a past citizenship application was denied. If the client did not become a citizen with a prior application because they failed on the English or civics grounds, that's perfectly fine. They're perfectly fine to move forward to the form station. If the application was denied for another reason, we likely need to see the records and refer out. Sometimes it can be fine if they filled out their application incorrectly and they left a lot of information out and then just never followed up. But again, we would really want to see those records. Examples of past application problems that would require more assistance would be that they were unable to show good moral character in a past application, that USCIS suspected fraud, or that they suspected a problem with the original grant of their legal permanent residency status. This is why we really want to make sure we understand why the application was denied in the past, and if it's anything other than failures past the interview, past the English and civics requirements, then we want to make sure we get that information from USCIS prior to giving that client advice. Question 11 deals with asylum and traveling home. People who gained legal permanent residency through a claim to asylum it's a very bad idea for them to have traveled home to their country of origin. We ask about this because it can result in a loss of protected status. The key question is if the government determines that they have voluntarily availed themselves of the protection of their country, it may terminate their asylum status. Generally speaking, entering the country can be enough to trigger that bar, depending on the circumstances. There are possible exceptions. For example, if someone traveled home for a very short period of time to visit a sick relative or take care of some other business, and they took great pains to hide themselves from the government or to to keep themselves safe from the government. Again, it's possible to get exceptions, but this will require one-on-one assistance. So if you have an asylee who has traveled home after being granted asylee status, please flag it and we'll refer them out for one-on-one assistance. Question 12 on the red flag checklist deals with bigamy and polygamy. We ask the client if they or their spouse has been married to more than one person at any time, because this can be a good moral character issue and an eligibility issue. This is especially the case and especially concerning if their LTR status or ability to apply for naturalization hinges on their marriage. Anything that threatens that marriage's legality in the eyes of the U.S. government is a concern. But it's also a concern even if it's not, if they're applying under the 5-year rule and they're not dependent on their marriage for their LPR status. Coming to the U.S. for the purposes of practicing polygamy, not just bigamy, is a mandatory bar to good moral character. And in addition, there are serious problems with any kind of deceit that may have been involved in marrying more than one person at a time. So we really want to look and make sure there's no overlap in the marriages. And this includes marriages that took place outside the United States, but of course, there's a greater level of concern for any marriages that took place inside the United States, and there will be clear records about. Questions 13 and 18 are getting at questions about false information to obtain a government benefit. Lying to obtain a government benefit, immigration or otherwise, is both a bar to good moral character and a potential removal issue. We really want to make sure the circumstances around this and really get a good sense of this if this is a red flag for your client. Especially of concern would be if USCIS found that the client received their LPR status or another benefit fraudulently, as this would result in a loss of status and potentially their removal from the country. But even false testimony for the purpose of obtaining an immigration benefit in oral, under oath, with no materiality requirement is a mandatory temporary bar. In other words, a bar within the 3 to 5 year statutory period. And even if the false testimony does not actually result in them getting the immigration benefit that they were hoping to get, this can still be a problem. So if they've ever told an untruth in order to try to get any kind of benefit from immigration or from any other part of the government, this is something that we really want to look into more and likely refer out for one-on-one assistance. The next question deals with alimony and child support, particularly child support. We ask about a failure to pay alimony and child support because this is a discretionary bar to good moral character. The key question here is whether that failure to pay was willful, as opposed to that they were unable to pay. So willfully failing to support dependents is a discretionary bar to good moral character. But if someone has been paying their child support, then lost their job, and is unable to make payments, but has tried to make payments whenever they can and really made a good faith effort, this is unlikely to be a bar. However, they will need to submit testimony and other information that proves that this was not a willful lapse in caring for their dependents. As I said, so proof that a client has tried but was unable to make payments may help with this, but gathering that proof and putting that together probably will require more one-on-one assistance than we can provide at a citizenship clinic. If you have someone who has failed to pay child support, try to get more information about why and what happened. and also when this occurred. It's important to know whether it is within the statutory period or not. Question 15 deals with helping someone enter the country illegally, otherwise known as alien smuggling in immigration law. We ask this question in a very broad and general way because we want to be sure that we are capturing how USCIS defines alien smuggling. Because it's not just physical people smuggling. It also includes sending money to pay for smugglers, or simply walking across the border with someone who is not allowed to enter the United States. This is a mandatory bar to good moral character if it's during the statutory period, but even more important, even if it was a relative, this is a removal issue. There is a waiver possible for a legal permanent resident who helped a spouse, parent, or child enter. But again, this is something that someone would need a significant amount of one-on-one assistance to obtain. It's not something that we can do at a citizenship workshop. We ask this question very broadly because we don't want USCIS officers during the naturalization interview to ask kind of a casual probing question and have someone voluntarily tell them something will get them into trouble, not knowing that that was in fact considered alien smuggling. Specifically, the example that we use sometimes is if someone's spouse is undocumented and they are in the United States, USCIS officer may ask them, so how did your spouse get here? And what we don't want is for our client to say, oh, well, I saved up money and I sent it to her and then she was able to cross the border. She came to be with me, because that would be an admission of alien smuggling. So again, we just want to kind of probe about this question, get a sense of the full picture, and ensure that this isn't going to be a bar. We ask about illegal gambling also because this is a bar to showing good moral character. Illegal gambling or 2 or more gambling offenses is a mandatory bar within the statutory period of the 3 or 5 year period. It does not require conviction, and it may be triggered by something that the client admits to in the interview. For any criminal conviction, obviously you want to see the criminal history section, and the same rules will apply that we need to see the documentation of their arrest and conviction. But we do still want to ask more broadly because, as I said, it does not require a conviction to trigger this bar. It can just be something that the person voluntarily admits during the interview. For problems with alcohol, we ask, because this chronic alcohol problem or habitual drunkenness can be considered a temporary bar to good moral character. Habitual drunkenness, which is akin to chronic alcoholism in the legal definition, is a temporary bar to good moral character. In other words, it's a bar to showing good moral character, but only within the statutory period. There's a number of important cases, and there's some question about whether this bar will continue to be used, but we just want to keep an eye and make sure that there's not something that's going to be a problem for our client. Again, if they have any criminal history related to an alcohol problem, for example, a DUI, then you want to see the criminal section for guidance about how to refer that person. Question 17 also deals with problems with drugs in addition to problems with alcohol. A drug problem can signal a potential removal issue and can be a serious problem. If we think that someone may have a drug problem that may come up in their USCIS naturalization interview, we're going to want to refer them to one-on-one assistance. A conviction or admission of a controlled substance offense is a temporary mandatory bar, and it's also a removal issue. So it's a mandatory bar to showing good moral character if it occurred within the statutory period, the 3 or 5 year period. However, it's also a removal issue. Simply being a drug user or addict is a removal issue, as is any controlled substance violation. In Washington State and in the Ninth Circuit Court, there is a single exemption for a small amount of marijuana possession charge. But even in that case, you would really want to make sure that that person has one-on-one representation. And it's important to note that state-level marijuana legalization does not lessen the risk for legal permanent residence. So if someone was to walk into their naturalization interview and say how great they thought it was that we had recreational marijuana here in Washington State, and they really loved going to their local legal weed store and purchasing a brownie every weekend, that would be a serious problem for them. So we want to make sure that someone isn't going to voluntarily admit something like that during the interview. There's also this section that if USCIS has a reason to believe that the client or the person is a drug trafficker, that's a temporary mandatory bar. For example, if there's information in a police record but no conviction, where police have arrested this person multiple times or done surveillance, they know them to be a drug trafficker but have not been able to charge them yet, that kind of information would be problematic for someone applying for citizenship. That's why if someone has an arrest record, even if there are no convictions, we really want to see that information before we go forward. Questions 19 and 20 deal with contact with an immigration officer. We ask about contact with an immigration officer to uncover past detentions, removal proceedings, or other interactions with the immigration system. We're looking for the possibility that the person is inadmissible at the time the client became a legal permanent resident because of something that happened in the past, and also problems since they became a legal permanent resident. So anything that occurred after the client became a legal permanent resident is especially important to understand, but even interactions from before they became a legal permanent resident can have serious ramifications if, again, they were actually inadmissible at the time they became a legal permanent resident. They can retroactively lose their status and not be able to go forward. So if your client has had any contact with an immigration officer, they've been refused at the border, they've been detained, they've been deported, then you really want to gather all the details you can and then consult with your team lead. Likely anybody who's had anything more than a passing interaction with an immigration officer is going to need one-on-one assistance, but we really need to get all the details we can. Question 21 deals specifically with domestic violence. Any domestic violence conviction is a potential removal issue and must be reviewed with care. For example, a violation of a domestic violence protection order, which does not need to be a conviction, can even be just a court finding, is a removal issue. And conviction of a crime of domestic violence after 9/30/1996 is also a removal issue. It must, in this case, it must be a crime against a protected person, and the crime must be a crime of violence. But again, so those are both removal issues, so something we take very seriously. Simple assault, even if it is domestic violence, is not a crime involving moral turpitude. According to case law, the domestic relationship alone is not enough to bring in moral turpitude. But any conviction around violence, such as assault, battery, etc., must be reviewed and probably will require a referral to one-on-one assistance. Questions 22 through 25 deal with questions about criminal history. Any kind of criminal history, whether it's an arrest, a conviction, a stay in jail, anything involving the criminal justice system, you really need to have court and police records in order to make a real determination whether this person can go forward or not. So the biggest question here is if they have any yeses in this section, if they've ever been arrested, ever had a serious interaction with the police, if they've ever been to court or been to jail or prison, it's very important that they have those records with them. If they have brought their records, then you'll send them on to complex cases to get a further review from a criminal attorney, so an attorney who has experience with both criminal law and immigration law. If they don't have the documents with them, we'll send them to a referral expert. We'll talk them through how to get those documents and then give them a referral either to a future clinic or to a one-on-one service such as one of our partners or a private immigration attorney. Any criminal history of any kind, any arrest history of any kind is a concern and needs further review. So the important things to understand when you're looking at the ramifications of a client's criminal history is to understand, is it a conviction? Is it an admission? Is it a bar to good moral character? Does it make them removable? Again, this is more for your background. Complex case experts will review any client with a arrest history or conviction to determine if they can move forward or not. The vast majority of criminal cases will be referred out for one-on-one assistance. We cannot help anybody who has come to a citizenship workshop without their police or court records. Sometimes if someone has brought their police and court records with them, they have a single DUI that was outside the statutory period, as an example, then they may be able to go on without any further representation. But we really need to be very cautious in the case of anyone who has any kind of criminal history or interaction with any part of the criminal justice system. The last question on the red flag screening sheet deals with association with terrorism, communism, or gangs. We ask about association with terrorism, communism, or any gangs because these can bar applicants from naturalization. Any association should be flagged and probably requires one-on-one assistance. There is one major exception, however. If a legal permanent resident was forced or required to join the Communist Party in their country of origin, I think the clearest example is China. There is an addendum that we have already prepared where the person can state that they joined the Communist Party because they were required to do so by their country of origin or required to do so in order to seek higher education, etc. And then there is an addendum there that they can sign and then move forward with relative ease. I'm going to talk a little bit about good practice tips involving good moral character questions. As I've said numerous times throughout this training, look at the date of the bad act. So not the date of subsequent court interactions. That we are always looking to see if something is within the statutory period or outside the statutory period. So the date the event happened is very important. So it's critical to note that the date the act occurred is how the USCIS dates it, not subsequent interactions with the court dates, etc. If they're applying under this, if they have something that is borderline, then we want them to apply under the 3-year rule if that's possible for them to do so. Generally speaking, we default to a 5-year rule. We don't want to put extra scrutiny on their marriage and extra paperwork onto their application if we don't need to. But if they do have something that was a bad act that could potentially be a problem with good moral character that occurred, say, 4 years ago or 4.5 years ago, so it would be within the 5-year period, then we'll have them apply under the 3-year rule if that's possible for them. We also often can advise folks to consider waiting to file their naturalization application until that bad act is outside of the 3 or 5-year period, outside of the statutory period. And again, in order for us to make any determination that is involved with the criminal justice system, we really need to have the records. So we must get certified copies of all court records before filing. It's important that they never send a sealed police report. And most clients with a conviction of any kind will need at least some one-on-one support. These are more, again, for your knowledge and information. All of our clients who have any kind of a good moral character question will be reviewed by the team leads and by the attorneys. But it's good for you to understand the situation and the sort of environment with it, which good moral character operates in the naturalization process. Now, I'm going to go over the N-400 and I-912 forms. I won't go over these forms in much detail, just give you a general sense of the form. Folks who have experience in immigration law or experienced immigration attorneys will be filling the role of the N-400 reviewer and will be reviewing N-400s and I-912s in depth. Non-immigration attorneys or newer immigration attorneys who don't have experience with naturalization won't be in these roles, but may be asked to fill the form filler role or actually fill out N-400 applications as the day wears on. If this applies to you, I strongly encourage you to take a look at the N-400 training for the form filling volunteers. What I'm going to do now is a very high-level overview, not an in-depth discussion. If you're an immigration attorney and you're familiar with naturalization and the N-400 form, you can stop watching the training at this. So first, the basics. It's important to write the A number on every page. You'll want to check to make sure that that happened. If you're reviewing and if you're filling out the form, make sure that you do this. This is so if any of the pages get separated, they can be reunited. It's important to use black ink only, no blue ink, and to write in all caps and to write legibly and clearly so that's easy to read. If you make a mistake, it's not a problem at all. We have plenty of whiteout available. You can correct it and start again. Now I'm going to go over just the basic parts of the N-400 and what each of them cover. But again, if you want more information about the N-400 application itself and a detailed discussion of how to fill it out, then please see the form filling training that will also be available on the OIRA website, or you can email your volunteer coordinator to get more information about that training. So parts 1 through 3 are of the N-400 application. Establish their eligibility to apply for citizenship. They will state if they're applying under the 3 or 5 year rule or a few other more complicated exceptions. They'll put in their basic information, their basic name and A number, etc., birth date. And then there's a place for them to fill out anything that they need to state around accommodations. So if they qualify for an English waiver, there's a question there. If they may qualify for a disability waiver, there's also a question about that. And if they need any other kind of accommodations, such as someone who is deaf or blind or moved and impaired and needs to make sure that the building is accessible, for example. Parts 4 through 7 deal with contact information, addresses for the last 5 years, their demographic information, and oftentimes you can just copy this off of someone's driver's license, it's the height, weight, eye color, hair color, etc., and information about their parents. The form asks about parents to determine if this person may actually already be a citizen. The contact information is so that USCIS can contact this person about their application and send them information about when their interview is, etc. And the addresses and demographics are used to run background checks. So it's important that they have a good current address and that they list all of their previous addresses for the last 5 years. For demographics, one thing I quickly want to point out, most of this is fairly straightforward. However, for USCIS, Latino or Hispanic is considered an ethnicity and not a race. So there's a question about if someone is of Hispanic origin, and then there's a race question that does not include a choice for Latino or Hispanic. This is often something that throws our clients for a loop. USCIS officially recommends that people who are Latino or Hispanic choose white as their race, but many of our clients are not comfortable with this or doesn't feel that this adequately describes them. You can have your client choose whatever race most closely describes them and that they're most comfortable with of the choices that are available. Part 8 deals with work history. Again, we want work history for the last 5 years. It includes periods of unemployment and time as a student, as well as traditional jobs. There is a limited amount of space on the form, and many of the people who come to a citizenship workshop will have had multiple jobs even at the same time, and many jobs over a period of 5 years. So we often have to attach an addendum here. Part 9 deals with travel. Again, we're looking here for flagging any trips over 6 months or trips that total close to half of the statutory period. So if anyone is applying under the 5-year rule, if they are getting close to 850 days, the cutoff is 913, but it's so easy to forget a day that if they're anywhere even in the neighborhood of half of the statutory period, we really want to flag that and look at it carefully. Part 10 of the form deals with marriages. Again, here USCIS is looking for overlapping marriages, and they're looking also at legal permanent residents who got their status through a marriage and then were divorced. If you have someone who became a legal permanent resident through a marriage and then was divorced fairly quickly afterward, you may want to ask them some more questions about this and get a better sense of the situation. Part 11 deals with children. It's important that all of the applicants' children are listed: stepchildren, adopted children, even deceased children, children who are outside the United States, and children who are inside the United States. This is less of a problem for the client itself and more of a problem potentially for their children. If a child is left off of their naturalization application, their parents' naturalization application, they won't be able to derive the benefit that they may want to later, either through becoming an automatic US citizen or by being able to come to the United States. Part 12 deals with good moral character. So this section covers false citizenship claims, human rights violations, selective service registration, arrests, and convictions. It's an extensive section, and really any question that the person answers yes to in this 1 through 44 of Part 12 is a potential problem. One thing to note is that there's also a way to show positive markers for good moral character when they're asked to list memberships. Here, USCIS is really looking for memberships in organizations that they consider to be problematic, such as a terrorist organization or a gang. But your client can also boost their good moral character by listing themselves as a member of a church or a member of a local volunteer group. And in some cases, especially if someone has some bad acts within their statutory period or in their past, it may be useful for them to bolster their good moral character bona fides by listing some of these positive associations and also potentially having someone write a character letter for them. Part 14 and 15 are where the interpreter will sign if that person qualifies for a waiver and had an interpret during filling out the application, and then where the attorney will sign as a preparer with the workshop's information. The workshop's information, how we fill it out specifically for that workshop, will be posted in the attorney review line. If you are acting as a form filler, you will not fill out the preparer section. It will be the attorney who reviews and signs off on the application. Now we're going to talk about the I-912 or fee waiver. Again, this is a quick overview of the I-912 fee waivers. If you would like a full training about how to fill out the I-912, who qualifies, and a lot more detail, then please see the separate module for the fee waiver training. The form station will screen clients for eligibility for a fee waiver and complete the form if the clients are eligible. Then attorneys in the attorney review role will complete the I-912, check it over, and be sure to sign it. For eligibility, it's low-income applicants can apply for citizenship or other immigration benefits for free if they meet one of 3 criteria. The first pathway is receiving a means-tested benefit, such as food stamps, TANF, Medicaid, SSI are common. Pathway number 2 is households who are under 150% of the poverty line based on income from last year's taxes, a letter from employers, or pay stubs. And USCIS requires a full 12 months of information. So often taxes alone are not enough. It needs to be taxes plus a letter from an employer or taxes plus a pay stubs for each of the months since the last taxes were filed. Pathway number 2 requires more scrutiny and more paperwork. So if it's at all possible, we prefer to have clients apply under the means tested benefit pathway. If they don't receive any means tested benefit, then we'll go to pathway number 2. The third way someone can qualify for a fee waiver is if they have a compelling financial need or extreme and unusual financial hardship. An example here would be a large amount of medical debt. However, we don't do pathway number 3 at citizenship workshops. That simply requires too much information and too much paperwork. If you have someone who you think may qualify under this third pathway, you can refer them to one of our partners for more help. So for fee waivers, a couple of things we want to make sure that we're doing is checking their income against the cutoffs, making sure for a public benefit that the client has documentation, making sure that the income is really below that cutoff of 150% of the poverty line. And we should have charts available in the attorney review section and, of course, for the form fillers that have the 150% of the poverty guidelines chart. So they'll have the household size and the yearly income cutoff for that particular household size. It's important to note also that unless a client is a refugee or an asylee, it's important to check whether the client started receiving benefits within the first 5 years of a legal permanent residency. Many, although not all, benefits are not available to legal permanent residents within the first 5 years, and if they did receive them, it may warrant further investigation. We want to make sure that someone wasn't receiving a benefit they were not entitled to, because this then could trigger a number of serious problems for their application, including potentially removability. Just for your information, Washington State food assistance is available to legal permanent residents within the first 5 years, so that is an exception to that question. But if you have any doubts, we'll have a number of BIA accredited representatives who are very familiar with fee waivers who will be available to answer questions. Now, and when we're talking about screening for a fee waiver, the first thing we want to find out is, does the client receive a means-tested benefit? Common means-tested benefits we see are food stamps, otherwise known as SNAP, EBT or basic food, Medicaid, also known as Washington Apple Health, and supplemental security income, SSI, for elderly, blind, or disabled people. Now, note, supplemental security income is not Social Security. They're easily confused, but they're not the same thing. The second question is, did the client bring proof with them today? They will need to have a recent award letter from the agency that awarded the benefit. In this case, we're using the example of DSHS, to certify that they received the benefit. This is the gold standard of proof and what we really look for. Recent means less than 3 months old. It should have the letterhead of the agency in question, the client's full name, the date the benefit began, which should be a date in the past, the date the benefit expires, which should be a date in the future, and the name of the benefit they are receiving. It's important to remember that means tested means the government agency has evaluated their income and awarded them the public benefit. The reason that USCIS and we prefer the means tested benefit pathway for a fee waiver is because they have already undergone scrutiny of a different agency to be sure that they qualify for the benefit. And USCIS then takes this application with a little bit more trust, knowing that another agency has already checked this person out. I'm going to go over a couple of common questions about fee waiver eligibility based on means-tested benefit. Often we have people who ask if their child receives food stamps or Medicaid, but they do not. Are they qualified? The answer is no. The person must actually be qualified based on an adult receiving the benefit. However, if a client's spouse receives food stamps or Medicaid, but the client does not, yes, they are qualified because USCIS is looking at the household as a whole unit. So if the household is receiving food stamps or Medicaid, then the person should be eligible as long as they reside with their spouse and are part of the same household. Another question is an adult who lives with their parent or parents who receive a benefit, the parent receives a benefit. Are they qualified? A narrow slice of the population is in fact qualified. If someone is between 18 and 21 years old and unmarried and living with a parent who receives a means-tested benefit, then this person would be qualified for a fee waiver. The classic example here is someone who is a student living at home, unmarried, whose parents may be receiving a benefit. Another question we often see is if someone receives Medicare or Social Security. The answer is no. These are not means-tested benefits. They're based on age and available to everyone regardless of income, so they do not help someone qualify for a fee waiver based on means-tested benefit. And the last is supplemental security income, which is distinct from Social Security. It's available to elderly, blind, and disabled low-income people. It is a means-tested benefit, and it does qualify you for a fee waiver. But again, it's important to ensure that you're not confusing SSI with Social Security. Now I'll talk a little bit about fee waivers based on household income. Again, this is our second choice. We really prefer to use means-tested benefits whenever possible. For an income-based waiver, the income of every adult in the household is counted. It's also very important that the household size match the recent tax return. If it doesn't for some reason, for example, the person had a child between filing their most recent taxes and the date of the citizenship workshop, please flag down one of the BIA representative experts to help you. It's also important to remember that unemployment and child support count as income for the fee waivers and must be included in the calculation. Also, it's very important that they show a full 12 months of proof of income, taxes, plus check stubs for all of the months. If USCIS sees a gap or they only provide, say, 6 months of information, they will go ahead and assume that the gap is there because that was a month that the person had an extra job or somehow received more income that would have put them over the top. So it's very important that we show a full 12 months of proof. One final note before I move on from fee waivers, it's important that you also make sure that they signed the fee waiver. That's a common mistake that we see. So now I want to move on to a couple of final notes before we end this training. First of all, most attorneys will begin the day in screening. We really want to stack our attorneys in the morning in the screening role so we can get as many people going through the N400s and really into the process as possible. As the initial rush in the morning slows down, we'll begin moving people who are qualified into the attorney review role. And if you are a non-immigration attorney, you may be asked to fill in the role of an N400 form filler later in the day. We will have a computer available in the attorney rooms to look up information, and as a resource to you, we'll also have a resource table, a resource box, and an attorney binder at your station. But please bring any materials that you like to have as a reference with you. Also, keep an eye on your email. We'll be sending important updates as the date approaches, and we don't want you to miss anything. And finally, volunteer roles are pre-assigned, especially for attorney volunteers. It's imperative that you give us notice if you can't attend so that we can shift things around and make sure that we have enough volunteers in every station. Finally, thank you so much. Giving your time means that hundreds of people can take the next step in becoming citizens, being able to vote, reunite with their families, and pursue their dreams. Without you, citizenship workshops would be impossible. And we really appreciate you taking the time out of your weekend to attend and help, and the time to watch this training. Thank you so much, and we'll see you at Citizenship Day. If you have any questions, please feel free to contact Elsa. Her information is on the screen in front of you with any questions, and she will get you the answer you need. We love to hear from our volunteers, so please don't hesitate if you have any questions at all. Thank you for watching this training, and we'll see you at the Citizenship Workshop.